All right, everyone. Good afternoon. It's really wonderful to see so many faces in our discussion on the criminalization of disability. My name is Jamelia Morgan, and I'm faculty director of the Center for Racial and Disability Justice here at Northwestern Law School, along with my colleagues Kate, Dimitri, and Jordan. We are a part of convening this event, and it's really an honor to be on the stage with two scholars who have influenced my thinking and writing in very profound ways on this topic. Before we get started and I introduce our speakers, I want to start with a land acknowledgement. The Northwestern campus sits on the traditional homelands of the people of the Council of Three Fires, the Ojibwe, Potawatomi, Adawa, as well as the Menominee, Miami, and Ho-Chunk nations. All right. I want to introduce our speakers and get us started with our discussion. Professor Liat Ben-Moshe is an activist scholar working at the intersection of incarceration, abolition, and disability madness. She is an associate professor of criminology, law, and justice at the University of Illinois at Chicago, author of Decarcerating Disability, Deinstitutionalization, and Prison Abolition, and co-editor of Disability Incarcerated. I also wanted to note that if you are interested in learning more about both Professor Ben-Moshe and Steele's work, their books were the topic of a recent symposium at Feminist at Law, which can be accessible through Googling. There's a long link that I can't quite read, but if you Google it, you'll find it. I was able to also contribute to that edition. Professor Linda Steele is actually visiting us from Sydney, Australia, so really glad that you are here. Professor Steele is a socio-legal scholar researching disability, law, and social justice, with a current focus on redress and repair. She is an associate professor of law at the University of Technology, Sydney, author of Disability, Criminal Justice and Law, Reconsidering Court Diversion, published in 2020, and co-editor of Sites of Conscience, Place, Memory, and the Project of Deinstitutionalization. So our plan for today was to really have a conversation. As I said, these scholars have influenced me greatly. I want to say we're of a small group thinking specifically about the criminalization of disability in the academy. And in many ways, we are pulling from different frameworks to try to understand the problem. All right, so I want to start with the basic question. What do we mean when we say the criminalization of disability? I'll give a quick story and then I'm going to turn it over to our panelists. When I first started writing about this topic, I remember I used the phrase, the criminalization of disability, in a law review article that I was writing. And one of the very bright student editors said to me, "Professor, what do you mean by this particular phrase? There's no law that as written makes it a crime to be disabled. You need to clarify." And I realized in that brief interaction through the notes and the comments that I had an entire field of work that I needed to do to break this down. Because indeed, I didn't mean that there were laws that specifically criminalized people, labeled people, the status of disability, and then, imposed a criminal sanction. But I meant something deeper than that. And so I turned to Decarcerating Disability. If you know me well, you know I cite this book all the time. I recommend students read it. I also discovered Linda's book, Professor Steele's book, not long thereafter, to try to figure out the processes that contribute to what we call the criminalization of disability. And so I want to start with our panelists. How do you define the term? I'll ad lib. They hear from me all the time, but I'll ad lib a little bit to the conversation, of course. Supplement what you share. But what does the phrase, the criminalization of disability, mean to you? And then how does this come up in your work? So also a chance to tell us about your work.
Hello, everybody. Okay. Yes, on-ish. Okay, cool. Hi, everybody. So the thing that, hi, I'm Professor Ben-Moshe, down the road from UIC. One of the things that I often tell my students, undergrad students in criminology, is that we have to understand criminalization as a verb. So, to build kind of on the story that Professor Morgan just shared, is that often when we say something is a crime, or especially in criminology, people often say, well, we shouldn't, if you didn't want to do the time, don't do the crime, something like that. But we don't understand the processes of criminalization. And criminalization is a verb, it is a process. People are not born criminals, people do not crime. We make things into crime, we criminalize, we socially, culturally, sociolegally. And so the criminalization of disability, to me, is very much entangled with racism, particularly anti-Black racism, but not only. And it's very much tied into what I call pathologization. So this is a process that in my book I call racial criminal pathologization, which means both of those things as a verb. Racialization, criminalization, and pathologization. And pathologization, that means medicalizing people, for example. So people are also not born disabled. They might be born with an impairment. A lot of people become disabled or become impaired, later in life. But disability, disablement, and pathologization is something we do: social, cultural, sociolegally, and so on. So those three things, again, are verbs. And the discourse or the process of racial criminal pathologization is a very interrelated process by which, we can, if people don't understand what I mean by pathologization, I mean things like medicalizing particular things as a site for intervention for medical professionals. I also mean psychiatrizing people. So a site of intervention for particular, the psychiatric profession. And those are pathways that lead to policing, to surveillance, and sometimes to incarceration and confinement. And sometimes that confinement looks like confinement in jail or prison. This is through the route of criminalization, but sometimes the confinement is through just the route of medicalization. For example, confinement in psychiatric hospitals or disability institutions. But the process is, it's like a Venn diagram, right? In which racial criminal pathologization is in the middle of those three processes. And I'll just end by saying that the problem with this process is that it is very much connected to what Ruthie Gilmore called susceptibility, differential susceptibility to premature death, which is her definition of racism. So again, differential susceptibility to premature death, her definition of racism, meaning that in the US, anti-Black racism in particular is composed of both pathologization and dangerousness, which leads to criminalization. So again, I can give a lot of examples, but just think of it as a kind of a Venn diagram in which racial criminal pathologization is in the middle of that. And that process also entails dehumanizing people and criminalizing people, and again, leading to surveillance and differential kind of life outcomes.
Thank you so much, Liat. I mean, one illustration of racial criminal pathologization is our reaction to individuals that are labeled in mental health crisis, right? The sending out of police very often, the pathologization in constructing the crisis point as the problem, and the fear of danger, uncontrollability, what have you, that makes it so that we kind of unquestioningly use police in those interactions might be an illustration of that. And I think, Liat, your work shows us the tentacles of how this is happening, the modalities. Professor Steele, Linda, can I call you by your first names? It's so formal. But Linda, could you talk a little bit about how you use the criminalization and disability framework?
Sure, thank you. Yeah, and in Australia we usually just go by first name, so it feels very formal. Yeah, so I mean, I'm coming from a legal perspective and from having worked as a lawyer and then thought about these issues in a research context. And I suppose when I think about disability in a diagnostic sense, we're often talking about what are the certain norms of behaviour or mental intellectual functioning in society. And then disability in medical terms is often about determining how people fail to meet those norms. So in a way, in a kind of medical context, disability is understood as an abnormality or a failure to meet certain norms. And so in the way in which disability is medically or socially understood, it's already seen as deviant or a failure to comply or meet expectation. And I think then if we move specifically into the criminal justice system and police, we can see the way in which police can interpret disabled people's behaviour, particularly, and I'm not talking here about all disabled people, but often disabled people who are socially marginalised and might be spending more time in public space, or disabled people who don't have their own private home to live in, whether that's they don't have any housing or they're in public housing or they're in disability supported housing or they live in a nursing home or aged care facility. When people have more contact with professionals and public space, then the way in which they behave and the extent to which they fail to behave like everyone else can then come to the attention of police. So I think, yeah, there's, I guess, two layers to criminalising disability. We can think about how disabled people come into contact with the criminal justice system. But I think we can also think more broadly about how disability in terms of social hierarchies is associated with deviance and criminality. And the other point I'd make there is that picking up on what Liat and Jamelia have talked about the way in which when someone with disability is criminalised, we're not just talking about people then being arrested and ending up in the police cell or in a prison, that disabled people within the criminal justice system are regulated and detained across a number of different spaces, including mental health spaces, disability service spaces. But also, again, taking a step back and thinking about medical approaches to disability. A lot of coercive interventions in relation to disabled people, particularly people with intellectual disability or psychosocial disability, rely on understandings of behaviour which have a kind of criminal are viewed in a kind of quasi-criminal way. So I'm thinking here about people with disability, regardless of if they've been charged with a criminal offence, can be subject to restraint against their will. And I'm not talking about police in the context of arrest. I'm talking about a disability service worker using medication, using a belt strap, you're locking a door, using a lot of different means to restrain someone, to detain someone in a way that we might typically think is only happening with the police and prisons. And that is allowed not because they've broken a law, but because they exhibit what's called challenging behaviour. And what is done to them is called restrictive practice. And if both of those terms are really new to you, then I think that's very telling about the fact that there are whole forms of interventions and ways of classifying behaviour that have a lot of parallels and similarities to what police do and what happens to people in the criminal justice system that are totally unknown to the broader public, including people who are studying law and learning about legal rights. And that all kind of traces back to this pathologisation of disability and that bringing together of the idea of deviant behaviour, but in a very disability-specific way. So ideas of challenging behaviour, people leaving their locked accommodation without permission. That's referred to as absconding. Again, it gives it a criminal feel that I guess kind of justifies doing things to people without their consent. So I might have gone off on a bit of a tangent there, and I guess just to reinforce what Liat has said, that this criminalisation of disability is an uneven process across the population. Not all disabled people will be equally subject to that experience or that process. And in my experience as a lawyer, we had a lot of clients, criminal justice clients, who were Indigenous or were living in poverty or lacked housing, were also drug users, or a lot had been in the child welfare system as well. So there's a way in which criminalisation kind of of disability intersects with other dynamics of power and oppression. And I think, and I know Liat would be able to talk to this much better than me, but there's, this is deeply entrenched in our current structures, but has a really long history and is tied up with ideas of eugenics. And I know Liat can explain all this much better, but I just wanted to flag one thing that I think is really important for, if most of us here are lawyers, is that there's a really famous image. And we might think of eugenics as something that, doctors do when they engage in sterilisation or, they're doing genetic testing. It's a very medical-based knowledge. But there's an image that was produced just over 100 years ago of a tree, and it's describing the role of all the different areas of knowledge in contributing to the growth of eugenics. And on the roots of the trees, there are different disciplines, and there's things like medicine and genetics, but there's also a lot of the human sciences or social sciences, including sociology, anthropology, education, and also law. So when we're thinking about how this criminalisation processes happen, how we come to understand disability through the lens of criminality and justify detaining and violating people with disability, even sometimes if they haven't even committed an offence, which is the typical kind of boundaries that we place around that kind of violence. And of course, we can question whether that's even correct. We've got to think about how is legal knowledge and legal practice contributing to that, and how what we're learning as law students or lawyers, is that setting us up to become part of that system.
Thank you, Linda. We're also going to be including some resources in the chat. I wanted to highlight something you said to bring it home to Illinois. There was amazing reporting by ProPublica, I want to say in the last year or so, talking about restraint practices in Illinois state schools, and the parallels between some of the coercive punitive practices that you would see in a carceral space, like a prison or jail, being practiced on school children with disabilities, right? To just bring it home a little bit more to us here. How else does society, Liat, criminalize disability? And you have pushed me to think also about madness, which might not be a frame that our students are familiar with. Could you talk more about that?
Sure. First, just to, in relation to what you were just saying about restraints, I just want to say, in the back, there's Dr. Dean Adams is in the back, who's done a lot of work on on and against the practice of restraints, particularly on children with disabilities in educational settings. So you should read that work as well. But in relation to your question, to give kind of some meat to the question of how does this happen? Like, we talk theoretically, right? But also, how does it happen in practice? And I'm going to answer it through the lens of both disability and madness. And madness is the kind of reclaimed word that mad activists claim as an identity and a culture and a source of oppression without using the medical terminology of mental illness. So it's a way to distance from the pathologization, but still acknowledge that it is something, that's happening, and it's a difference, right? It's a form of difference, but doesn't one that necessarily should lead to the pathologization, the kind of consequences we just discussed that come with it. So one thing to think about is how criminalization, I'm just building on what Linda just said in regards to eugenics, criminalization and pathologization together lead to an assessment of not what people do, but who they are. And this is why we're saying this comes from eugenics. Eugenics, of course, you know, this ideology and pseudoscience that said that we can better the human race. This is pre the genome project, so they use words like hereditary trait and not genes, because genes were not discovered until much, much later. But the idea behind, you know, eugenics is that one of selective reproduction. And so I want to give a shout out as an example, like what the hell are we talking about? There's a new book of a colleague of mine, Jess Watcott, that just came out, and it's about the history of what they call carceral eugenics in California, carceral eugenics. And the idea that they're putting forth in that book, that carcerality, being confined in itself, is a form of eugenics. Even if you don't get sterilized while in prison, which also happens in California and elsewhere. So absolutely, we should pay attention to that. But even without the kind of forced sterilization that happens, incarceration by itself is a form of creating selective reproduction, because you can't have access to sexuality, reproduction, family, even family that you have, right? Like the prison, disability institutions, nursing homes, they cut that off, right? And so these carceral sites create what Watcott calls carceral eugenics. Just as an example of what are we talking about here? The other thing is that, you know, a lot of things lead to criminalizing disability and madness, and some of them are just being different in public. And this is, you know, a lot of it is on us. I mean, we're the people who call the police, we the public, right? People are different in public. Sometimes they yell, sometimes people talk to people we don't see. Sometimes, you know, they do things that we think are strange. And so that is a way to criminalize like different behaviors that we often don't kind of understand, but doesn't mean that has to lead to this criminalization path. And the other example I want to give is the example of what's going on in terms of Palestine organizing. And you might not think that's related, but it's related. Because two things are happening now. Now, one thing is this, I'm just going to say, obscene spread of anti-masking laws. And this is both very ableist because, of course, it affects particularly those of us who are more vulnerable, like myself, to the spread of COVID and the differential outcomes that something like COVID has on our bodies and minds. And so anti-masking, right, means that, or laws that makes you unable to mask, it will become illegal to mask, absolutely creates differential outcomes for disabled people. And the reason why I'm connecting it to Palestine organizing is because, of course, this push for anti-masking laws and regulation and stipulations are against, you know, it's a push against the demonstrations and the uprisings and the resistance that has been happening last summer in the US in regards to encampments and so on. The other ways in which I see that is connected, the way criminalization steeps in to madness, is that some of the protesters, and there's specific incidents of that, I'm not making this up, in some of the encampments, in some of the protests, because there was not an immediate direct pathway to criminalize at that moment, after the fact, there was and is, and a lot of the people who participated, maybe some of you, in these protests have been criminalized and are being criminalized right now. But in that moment of the protest, when there was no direct path to criminalization, pathologization was the path by which people were removed. So people were called crazy. Some people were removed by concern for their mental health. These were students, a lot of them like you. And some of them have histories of mental health difference. None of it had to do anything with the protest, but that was a way of like removing people from participating. You know, and again, another way to either threaten people with like, I'm going to call, instead of the cops, because there's nothing to call the cops in that moment, I'm going to call social services, I'm going to call an ambulance, I'm going to call, you know, and so on. And some sites did. And so I think that there's a lot of ways to think about, again, that nexus of racial criminal pathologization and the criminalization of disability beyond kind of the obvious. And I think there is a lot of obvious. But again, I'm just giving Palestine organizing and carceral eugenics as just two examples for us to kind of think through how that works. The last thing I want to say about that is that and maybe we'll talk about it like in the next question, so I'll just like put a pin on it, that the law is a pathway to do that work. So of course, in terms of anti-masking laws, I mean, of course, the law is going to be a pathway to make that work, but also in the ways that people are constructed as terrorists, for example, has a lot to do with discourses of madness, discourses of who's pathological, who's irredeemable, who cannot, which are also eugenic discourses, who cannot, you know, what is the even need to put somebody through due process, right? They're crazy, they're a terrorist. And even if they haven't done anything, which is what Guantanamo is, we should still detain them because they might do something. So this, again, this very American, I think, I don't know, you tell me, notion of like, that I know exists also in the kind of Australian context as a kind of a colony of exile, is that, you know, this idea of indefinite detention and the idea of preventive detention is a eugenic practice, meaning it's not about what somebody did, because people didn't do yet. It's about who somebody is. And then this idea of criminalizing and pathologizing people for who they are and what they might do in the future.
Thank you, Liat. I mean, just to maybe quickly react and then, you know, switch to a conversation about the law. I mean, this topic of preventative detention, for those of you in, you know, criminal law or took it last year, the year before, you know, we often talk about the distinctions between the power to punish and then the power to kind of hold somebody civilly liable. And you spend time trying to figure out that distinction. And there's usually like a paragraph in every case book where they'll say, well, you know, the power to punish, you know, the power, the police power kind of looks like, you know, the power to quarantine a person or to civilly commit them, right? And like, what are the distinctions? And then we sort of shy away from having that longer conversation that there might not be much distinction, that we are talking about the power to police people, to lock them up criminally, and then the power to pathologize them and then detain them indefinitely is sort of operating in the same way with important nuances legally, but with the same ultimate effect that an individual will be locked in a cage, whether it's a hospital or a prison or a jail. And so I wanted us, because we're here in a law school, to kind of grapple with the critique. You know, how should we think about the role of law in both perpetuating and ending practices that criminalize on the basis of disability? Many of us are thinking about the role of law in creating the ableism that we experience maybe in law schools and cities and our workplaces. There's somewhat of a relationship here that we have to sort through. And Linda, I know that, you know, when I read your book, that's what I was given. And your chapter 7 of your book, which I always remember because it was so spot on. There is a relationship between law and perpetuating the kind of ableism that we're seeing, you know, reflected in the criminalization of disability. And that can be true even with well-meaning advocates, right? Even if there's litigation to improve conditions of confinement, we might still see the same sort of practices that contribute to ableism. Even if there are well-meaning mental health workers and social workers, they can still contribute to these practices where aided by law. So what do we think about the role of law in perpetuating, and then maybe so that it's an optimistic note in some sense, possibilities for ending?
Thank you. Yeah, so I guess if we're thinking about the role of law, we kind of need to go back to those first principles, the things not that we're going to learn about in a special subject on mental health or disability law, but the kind of things that are in the background in some of the core principles you learn about in tort law and criminal law. I'm talking about the importance of capacity, whether that is the importance of capacity as a justification for trying the fairness of the trial, capacity, rationality, those kind of concepts related to the appropriateness of and justice of imposing criminal responsibility. Or if we're thinking about victims of crime, the significance of capacity in determining consent and bodily autonomy. So I don't know what it's like here, but when we teach and learn about criminal law and tort law, we basically are focusing on the principles that justify those systems of law and the infringements on people's liberty and autonomy and so on through punishment or, for expecting people to pay damages and so on for civil wrongs. But in the background, we have cases that at the same time, like in Australia, we teach tort law and the law related to assault by reference to a couple of cases related to sterilisation of women with disability. And we're not learning those cases because they're telling us that women with disability, because they can't consent, can be subject to sterilisation still against their will because someone else is allowed to consent on their behalf. We're actually reading that case, not for the violence of those facts and what that law is enabling. We're reading it for the little bit of that case that tells us the principle that consent is at the core of civil and criminal assault, and it's enforcing or protecting people's bodily autonomy. So I think there's probably a lot you've already learnt about disability and the role of law in criminalising or violating disabled people, but you might not even have noticed because the way in which we read those cases is for a different purpose, and that in itself is ableist because we can just brush over the violence of those facts. So I guess what I'm getting to then is that there are a lot of laws that are disability specific. They apply only to disabled people because and specifically people with intellectual and psychosocial disabilities, because they're considered fundamentally different because of capacity and how that then shifts who has the power to consent to things happening to people's bodies. So some of these laws are civil mental health laws, so forced mental health treatment and detention, guardianship or conservatorship laws, which everyone probably heard a bit about in relation to Britney Spears, and they got a temporary wider interest to the general public, and also forensic mental health laws. So these are laws that say, okay, disabled people who are charged or tried with criminal offences because of their disability, we can't convict them or we can't give them a trial. For anyone else who's in that situation, say because they've engaged in conduct in self-defence or in an emergency, if they can't be convicted because of those defences, then they're free to go in general, unless it's something like excessive self-defence. But in general, we say these are the boundaries that we're placing on what the state can do to people in criminal law. But if someone is found not guilty or unfit related to disability, then they are shifted into a whole other legal system called forensic mental health that then determines how they will be detained or controlled in the forensic mental health system. And that could be in a purpose-built mental health facility for people in that group, they could end up in prison if there's no treatment available, which is generally for people with intellectual disability, or they could end up in the community, but in a locked group home and subject to restraint. So law enables people with disability to once they enter into the criminal justice system through contact with police, enables people with disability to be subject to a wider range of options for detention and coercion than what is possible legally for other people. And that can also go on for years. So mental health and guardianship laws can often be, they're often not time limited, or they can be renewed. And I guess the other thing I wanted to say on that is that that while we're talking about criminalisation of disability, we also need to think about how the same logics and ideas about disability and capacity within law, on the flip side, also then keep disabled people out of the realm of being recognised as victims in law, and then being able to access redress when they are subject to some kind of violence that would otherwise be considered illegal. So, and I think that, in law, we often think of offenders and victims as in a kind of dichotomy, but a lot of disabled people who are criminalised have also histories of being subjected to violence, exploitation, often related to not only related in the kind of private sphere in personal relationships, but also in terms of police, support workers, mental health workers, and so on. So I think part of kind of unpicking this, disentangling this relationship between disability and law and criminalisation and violence is to really go back to those foundational issues around capacity as structuring everything within law. And when that intersects with ideas we have about certain people with disability as lacking that capacity in a medical sense, then I think that's one of the core issues.
Yeah, Linda, just to echo a couple of things, when you think about the special rights discourse, as we refer to it, and for those of you interested, Professor Duran Dorfman has a paper about this. The special rights can also be a way of undermining rights, right? Not equality. And then for those of you in the 1L courses, note every point where you say, well, I wonder about people with disabilities, and it's deliberately not a factor to be considered, or it's not a framework that you can bring into analysis. A part of what, Linda, you're saying is like the erasure can also be harmful and can in many ways kind of perpetuate these pathologies that we're identifying. Liat, what do you think?
I'm going to shift the discussion a little bit, but I wonder if Linda, you want to talk a little bit about your work on reparations, because it is so not something we have here, and also in this context, and also I think a way to because I'm gonna, pretty much critique the law straight out, but as a way to just offer a little bit of kind of creative pathways of what the law might be able to do. I don't know. I'm just curious. So a lot of my work has been on the deinstitutionalization movement, or the movement that particularly closed down psychiatric hospitals and institutions for people with disability in the United States and somewhat in Canada, starting from the 1950s up until today. And so in deinstitutionalization, a lot of people might think that the law was a very big factor in doing that, particularly in terms of class action lawsuits. And some of you might, heard about some of these legal case studies because they did bring some very foundational questions into play. But what I try to kind of untangle in that work is, what did it do? Did that kind of legal work, even on a class action level, which is, much more than just not just, but, trying to free like an individual or trying to get redress for an individual. This is on a, broader scale. And I don't want to say that it did nothing. It absolutely is not true. It did have some effects that were very interesting to note, but also some unsavory effects. And so these class action lawsuits, both in the prison realm as well, there's been more and more litigation, particularly in California, around disability and overcrowding and what is that the overcrowding does to people with mental health differences. And that has been kind of an ongoing thing that ended in a decree that decreased the prison capacity in California. And it said, it can't be over, I think it was like 122% or something. I don't know, some really random number. But don't ask me why that. And it did lead to a reduction in the number of people who were incarcerated in prison. So I'm not poo-pooing this. But if we take all these kind of class action lawsuits as a whole, we can see that, and again, some were more pervasive in the 70s and 80s in the eras of litigation in the disability arena. It definitely had a cumulative effect, which I think somewhat was unanticipated. It really politicized people. It created movements, including movements of people with disabilities through these lawsuits, because these lawsuits, some of them lasted decades. So people got to know, each other, families of people with disabilities. Some of them, their kids are dead by this point, right? They know they're not gonna, it's over for their child, but they want to make sure that nobody else is going to live in this institution ever again. They want to close down this institution. They want to create a better, environment for people to come. So they stayed with these lawsuits. So it became a very important politicizing tool, which I'm not sure people were kind of knew that that's how it's going to end up. People, again, banded together, created movements, created very innovative like legal strategies. Some of it came very close to really putting institutions and prisons on trial, meaning what you're doing is unconstitutional. What you're doing is discrimination per se. Why are people with disabilities even in institutions? And I'm saying came close because it was not, kind of resolved in their favor. It didn't necessarily, in all cases, go that far. But in some levels, it also ended up in what the abolitionist organizer Rachel Herzig calls tweaking Armageddon. She has a really short, important open access article called Tweaking Armageddon about litigation, particularly about prison conditions and what that does. And what she says is you can try to tweak catastrophe, but you're just like playing with the part of catastrophe. You are not changing catastrophe, you're not stopping catastrophe. And so what the cumulative effect as a whole, again, some of this litigation was very important at political effects and so on. But as a whole, it did not question the actual rationale of incarceration for disabled people and for people more generally. The litigation around prison conditions, around madness and overcrowding absolutely did not ever question, why are people here? Why are we doing this? What is the rationale of confinement in 2000, whatever the case may be? And what it did is try to kind of chip at the margins, right? To say, maybe not this person, maybe not this population, maybe people with serious mental illness, maybe they can be confined in different ways. But nobody said not confined. And this is what the law does, that increases the scope of and the rationale of incarceration. It just chips at the margin, but the center is bigger and bigger and bigger. And it doesn't break through the center. And in fact, it increases it. And this is, in activism, we call this the dilemma between reform and abolition. And the law is a tool of reform at best. And often does harm at worst. And this is what I call, and I'll end there, in my work, I call this carceral ableism or carceral sanism. It's this idea, a belief, practice that people with disabilities need special, like Jamelia was just saying, special protection. They shouldn't be here. People who are mentally ill should not be in prison. People with this kind of disability should not be in this institution. But then what that does is that leads to the creation of a different institution or a different unit or forensic unit, or everything in Linda's work around, these kind of like quote unquote alternative pathways, right? The mental health, courts, facilities, diversion, that absolutely do not lead to the freedom of people with disabilities.
Thank you, Liat. So Linda, do you want to talk a little bit about reparations? We have about 7 minutes left, and then if there's time, maybe we can take a few questions from our audience.
Sure, thank you. Yeah, well, I mean, I'll be very quick, and just to say that, yes, as a law academic, it saddens me that the law can be ineffective and it can be harmful. And I think not only in the kinds of ways in which law enables all this regulation and violence, but also in terms of when people turn to law for justice or accountability, it can be harmful. And that includes courts, complaint processes, and so on. Often if you hear about people, speak to people who've had those experiences of those processes, they will talk about the being positioned as a complainant, of being seeing as someone who's complaining itself attracts extra punishment, and you end up feeling like you're the problem. So I think that's a really important thing for us all to think about as lawyers. If we're going into law or policy making, despite all their limitations, how can we make sure that justice systems are causing the least harm possible? But beyond law, if we think beyond disability, we know that there are other ways that people seek to get some recognition and accountability, or broader kind of community or social repair after mass harms or structural harm. And I would say that the way the current and the history of violence and segregation and institutionalization of disabled people is a structural injustice issue. So if we think beyond the disability context, we know that there are practices or approaches such as reparations. So where there's recognition that there's been a large group in society that's been wronged, generally by what a government has enabled to happen. And instead of saying, okay, yeah, something's wrong here, but each one of you has to go to the court and get your own remedy, there's recognition that in order for society as a whole to move forward, and in order for a large group of people to have some recognition and addressing of what's happened to them, and in order for us as a society to learn from those what went wrong, that there's a need for a wider scale response, and also in particular one that doesn't depend on people's injustices being only legible through law. So saying, okay, we're going to give some redress here, but only if it was a crime, because we know that a lot of the structural injustices, they're perfectly legal and they are supported and enabled by us as lawyers and judges and policymakers. So reparations is instead looking at, I know human rights also can be problematic, but looking at wrongs in terms of human rights violations, and then providing different forms of individual and collective redress, such as compensation and restitution, but also looking at collective forms such as memorialisation and public education and commemoration as well. And obviously there's big debates in the moment in the US around First Nations people and in relation to slavery and racial segregation. So you might think about what's possible, what's being talked about possible in that context, and think, well, how might that then be one way in which we can respond to this long history of harm, but also in a way that is also not just looking back, but looking forward and thinking, how are we actually going to learn from this and try and transform our legal systems and societies to stop this from happening again. And another big part of that is truth-telling as well, and thinking of ways that we can provide forums to actually listen to disabled people in terms of their experiences. And because, yeah, a lot of the things that happened in institutions, they're very closed, segregated settings. We don't actually know about that. And we have such ableism, particularly around people with intellectual disability, that a lot of the time society doesn't even think they can talk or they can articulate their own experiences. So, and I think as lawyers, you know, a lot of those ideas are ingrained into our professional practice. So thinking about how we as lawyers can not necessarily deliver reparations, but behave professionally in a reparative way, even in our small bit, to always be thinking about how can we prevent further harm, but also how can we ourselves take it upon us to learn about this history and support changes that might stop that constantly being repeated, as Liat says.
Well, we don't have time for Q&A, but I know that maybe we can stick around for those that can to answer some questions. But please join me in thanking our amazing panelists. And thank you all. Hopefully this is giving us a lot to look into, but thank you all for coming.